My name is Theodora Lee. I am a senior partner with Littler Mendelson in San Francisco. And I have the pleasure to speak today about ethical minefields and e-discovery, a perfect match. Well, you're probably saying, oh yeah, I know everything there is about electronic discovery. And you might, because it has indeed hijacked litigation away from the substance of the claims, especially in class action litigation. Indeed, e-discovery has become one of the most critical developments in the legal world, with e-discovery options ranging from sanctions against clients and you young lawyers too. So, why is ethics important? The ethical implications of e-discovery are critical to your practice because, number one, you have an ethical obligation to be ethical, and courts are emphasizing the need to engage in e-discovery practice. California's bar has issued opinions on the issue. And the opinion says that young lawyers, old lawyers, and those in between must have a basic understanding of e-discovery issues as a threshold matter to be competent in litigation. I just was speaking with a lawyer on a panel who is about 75 years old. He says he relies on the young associates in the firm to learn e-discovery. Is that meeting your ethical obligation? Absolutely not. Each and every attorney must be sufficiently familiar with e-discovery to meet its ethical obligation of competence. And that opinion lays out for you what competence means. You must acquire sufficient learning and skill before you perform legal services. You must associate with or consult technical consultants or competent counsel, or you must decline the client representation. Therefore, it is incumbent upon you lawyers to learn about electronic discovery in order to meet your ethical obligations. Moreover, you've heard of preservation of evidence. Whenever, if you're a plaintiff's lawyer, you send out a letter, a demand letter, make sure you include a letter of preservation so that they are on notice that you are going to be seeking e-discovery. And if you are a defense lawyer like myself, as soon as you get a demand letter or even a conversation with an employee who is claiming that they have been discriminated against or harassed, you immediately send out a litigation hold letter, which would put everyone on notice, including the decision makers, IT, and your human resources department, that nothing should be destroyed because you do not want to face a spoliation of evidence claim. There are sanctions that have been issued. There have been lots and lots of money, but more and more getting a jury instruction that pretty much presumes liability will devastate your client, and you will be facing a malpractice lawsuit. So it is very critical that once you are on notice of your obligation to preserve evidence, electronic and all, you need to do that. At the program yesterday, they asked a question. What about all of these social media sites? You know, can we change the private setting, the public setting to a privacy setting after notice? Absolutely not. You must maintain it as is once you are on notice. In addition to competence, in addition to preservation of evidence once you're on notice, you also have an obligation under the rules, ESI and federal court, to cooperate with opposing counsel. Now, the issue of cooperation is a very interesting one, and the federal rules require it. Many of the state superior courts, Alameda County, San Francisco, Los Angeles, have rules on ESI and your obligations for you to meet and confer with opposing counsel on the production of electronic information. Now, your opposing counsel has given you a list of search terms. And when you see the list, you note that they failed to list some really critical search terms that would definitely go to the heart of the issues in the particular case. They forgot to ask critical questions. You breathe a sigh of relief. Well, they'll never get this critical information because they didn't ask for it. The question becomes, does the duty of cooperation extend to helping the other side? And I have had this a conversation with a number of folks around the country. It's a very controversial issue. But I would say to you, you still have an obligation to your client ethically to represent your client's best interests. So if the other side has not done their homework and they have not specifically searched for the information, you're not to do their job. You're to cooperate and come up with ways to provide the relevant information. But you're not in the role of educating the opposing counsel against your client's best interests. Now let me talk a little bit about a scenario that I would imagine you young lawyers will face on a regular basis. You are a third or fourth year associate. You are doing document production. You're gathering all of these documents. They're groups documents you've gone through. Some of them are categorized as privilege. And you go to the senior partner who you work with, who is also on the shareholder selection committee, and you don't want to do anything but excellent work for this particular partner. All partners you should do excellent work for, by the way. And you bring to the senior partner's attention, this document says it's on a privilege list, and you name that it was shared with the outside auditors, and therefore if it was shared with a third party and it's no longer privileged, should it be on that privilege log? You have a conversation with that senior partner. He says, oh, it remains on there. Our accountants, they don't read what we send them anyway, you know? Have you met your obligation by just following the senior partner's advice? Absolutely not. You need to delve deeper and find out whether the document was given to the accountants under some type of privilege, whether they read them. Because if the privilege has been waived by actions of the attorneys or the client, it's no longer privilege, and it is your ethical obligation to ensure that you do that. Inadvertent email is another area that I think you as young lawyers need to make sure of. You inadvertently produce a privileged document and you don't have in place a clawback agreement. A clawback agreement is an agreement that you need to learn about, because before you start down the road of electronic discovery, you need to enter into a clawback agreement, which would provide that if there is an inadvertent disclosure, what the steps are to not create a waiver of a subject matter waiver. The federal rules address this issue. When you're in your meeting confer sessions at the outset of the case, you need to address this issue. So if there has been an inadvertent email sent, is there a privilege still or not? That is an area that you as young lawyers really need to get into and understand. And I know all of you think keyword searches is all you need to do in electronic evidence. Well, don't be fooled. Keyword searches are critical, and they are important for the discovery process, but you need to engage in a meet and confer process at the outset of the litigation. And if you're in federal court, they have actual guidelines that tell you what agreements have to be reached regarding ESI. And if you're unable to do so by agreement, you need to get the court involved. And with that, I think you can practice law in this time of great electronic evidence and still meet your ethical obligations. With that, thank you for listening.